Yes, thank you very much, Zishan and Idris, for the invitation and for the opportunity to learn from the audience and to reflect on comparative theology, which I normally don't do, unless I'm in a desert. Maybe this would be an opportunity. So because I'm in the same panel with Idris, I quickly ran up to my room and tied my tie. And I mean, after 2 years of having combined my shirt and tie with pyjama pants, I think this is a good feeling. The title of my presentation is Codes, Commentaries, Fatwas, the Function of Legal Genres in Islamic and Jewish Law. The beginnings of the comparative studies in Jewish and Islamic law goes back to the second half of the 19th century and have experienced a significant growth in recent years. There are several legitimate reasons for such a comparison. First, the long common historical experience, and secondly, the similarity of the two legal systems, which are also erroneously called nomocentric religions. Rituals and law are very important and integral part of both traditions, but I would challenge the assumption that to call them nomocentric religions, since this would imply that law is the center or the most important part of these traditions. At least for Islamic tradition, this would be too reductive, since law was always embedded in theological and in other contexts like tasawwuf. So we can't say that law is the center and the others are the periphery. But this also leads to the question of the place of law within both traditions, and this would be, I think, a good point of discussion. So law could be a platform of mutual learning between Jews and Muslims, or between Jewish and Muslim theology. And since there were numerous comparative studies in which various aspects of ritual, substantive law, and hermeneutics were analyzed, we have a good basis doing comparative theology. As for my topic today, the aspect of legal genres, however, in my opinion, has been neglected so far, and we can only find some marginal notes that there are parallels between the various literary forms of halakhic literature and Islamic legal literature. And Gideon Lipson and Lieberman, for example, mentioned that the first codices and the responsa collections, and thus the classical literature of Rabbinic and Karaite Judaism, emerged in the context of Umayyad and Abbasid rule between the 8th and 12th centuries, and there are several studies on usul al-fiqh within the Rabbinic and Karaite traditions. So since I'm currently working on the diversification of legal literature in Islamic law, and this aspect has not been highlighted in the comparative studies so far, to me this seems to be a good basis for comparison. So in both traditions, in Islamic and Jewish law, we see the emergence of different forms of legal literature, like codes, Murtazas, commentaries, super commentaries, fatwas, responsa, or court decisions, enactments. And it is obvious that these different genres serve different functions within the framework of legal discourse. The aim of this paper is to show the function of these different genres of legal literature within both traditions in the pre-modern discourse by focusing on the question of stability and flexibility. So how did scholars of both traditions manage the tension between stable/theoretical and flexible/practical law, and which function do the genres have in this process? My thesis is that in both traditions, there is a functional interplay between the different types of legal literature. While some stabilize the discourse, others layers of legal literature provide space for creativity and practicability. That means this diversification of legal literature had the purpose of managing the tension between the stable, static, ancient, sacred law on the one side and the current applied law on the other side. And contemporary Jewish and Muslim scholars frequently emphasizes the point that law didn't constitute, in a classical sense, a flat discourse, but a multi-layered one, where the embeddedness of law in social, political, and theological, intellectual context became evident. So first, yes. So this is the content, not really, but approximately. First, I want to show sketchily the diversification of legal literature in Islamic law, and then the diversification of legal literature in Jewish law with examples. And then in the third step, I try to conclude with common questions. So in a good rabbinic and Islamic legal tradition, I won't talk on theoretical reflections beforehand, so and just do it and reflect after the presentation on common theoretical issues. So to better understand this problem of the tension between sacred and applied law, I start with some quotes from Jewish legal literature about this relationship. I start with a rabbi from the 12th century, Migash from Spain. He said, the Talmud is all halakha lema'aseh, applied law. This is an important term. It is as if the Talmudic authors told us, this is the law to be applied, for they wrote it in order that it be performed in practice. So not only it is binding, but it should be applied law. And interestingly, many rabbis from the 11th century onwards consistently conceptualize the whole Talmud as applied law. But to this later. But if we look at Talmud, there we see other conceptions. So, so there we have the passage about Rabbi Yohanan, where he said, when our master has said to us, the law is thus and so, may we hand down rulings accordingly in actual cases? He said, do not hand down rulings accordingly unless I declare it law to be applied. So the Talmud in this conception is not all applied law unless it is declared so by a rabbinic authority. But then we have another citation from the Tosefta, from supplements to Mishnah, where it is stated, the case of the rebellious son never was, it is a case, nor will it ever come to be. So why then was it legislated? The answer, to say, study it and receive reward. So from these and many other statements, we see that there are many legal rulings in Mishnah and Talmud which were not for the purpose of implementation, but for studying purposes to get reward. Because they are either fictitious problems or rituals related to the temple, which doesn't exist anymore, or criminal punishments, which couldn't be applied without governance, etc. Since halakha is produced in the theological condition of galut, exile, that means that halakha has to function without the supreme legislative body known as Sanhedrin, and therefore cannot adjudicate or enforce significant areas of halakha. So how then to reconcile between the first statement of Rabbi Migash and the Talmudic statements? So obviously, not all the Talmud is applied law. Then here another quote from a 14th century scholar, Jacob bin Asher, who wrote a very influential, one of the very influential codes in Jewish legal tradition, the Arba Aturim, where he said, the judges are required to distance themselves in all possible ways so as not to accept upon themselves to adjudicate according to the law of the Torah, for their hearts have been considerably diminished. So, I mean, for Talmud, it was understandable because it contains not only legal content, but also other narratives. But for a codification work like Arba Aturim, which explicitly had the aim of collecting only the laws which are relevant and applicable, this general statement is very strange. So the first author said all Talmud is halakha lema'aseh, and Jacob ben Asher said don't apply the laws. So on the one side, there are statements where they say that these are binding rules, and other side there are statements about not applying them. Rather than understanding these statements as contradictions, one should look for other options. That means we cannot understand these statements in a literal sense, otherwise it wouldn't make any sense. So we have to qualify these statements and have to look to other material, to other legal genres. And if you look at the responsa written by Migash and responsa written by or issued by Ben Escher, the issue became clear. What Migash means is not that all the Talmud should be applied, but for him it is important to preserve the halachic authority in a time where the yeshivot in Babylonia hasn't the same authority, hadn't the same authority as they had before. So it is about preserving the authority, because in his response he frequently mentioned that the jurists should not apply all the halakha, they should rather apply the rulings of the poseks, of the muftis. And a similar thing you can say for Jacob bin Asher. What he means is that the judges should be aware of interpreting so much into the Talmudic literature, they should rather apply the concrete rulings of the muftis. So qualifying general statements by using different genres and differentiation between the different modes of laws helps us to reconcile these statements. So now move to the Islamic legal literature. So also in Islamic legal literature, we have different layers of legal literature, as I have said, and these have different functions. And there is division of labor between the text forms. While some stabilize the discourse, others make room for practical solutions. At the very top is the Mukhtasar, and together with the commentaries and super commentaries, it forms the most stable theoretical level. While the codes lay down the black letter rule, the commentaries explain these rules in the light of the discursive tradition. The above three primarily represent the legal doctrine of the early schoolmasters, whereas the fatwas, treatises, and sijilat are more related to the legal practice. While the above genres treat the law in a systematic, abstract manner, thus stabilize the law, the genres in legal practice are responsible for contextualizing the law and make it more flexible. So now let's go back to the tension between abstract and applied law as we have seen in the Jewish context. So, as I told, there is a hierarchy between these text forms, and a quote from an Adab al-Mufti text says following: "The Mukhtasar and the commentary have the task of transmitting the school doctrine. Therefore, what is written in a fatwa may not contradict these two textual genres. The Mukhtasar take precedence when they contradict the rulings in the commentaries, and the commentaries take precedence when they contradict with the rulings in the fatwa. So there is a clear hierarchy between these texts. The Mukhtasar and the Sharh have the highest authority. But then we have another statements which seems to put the previous statements into perspective. There we see the abstract statements of the codes are not taken, of the Mukhtasars, are not taken into account when giving fatwa, and it is not permitted to give fatwa on the basis of these abstract statements. So they have the highest authority, but because they are abstract, they are universal codes, they cannot be applied without considering the context. Why? Because the abstract statements of the codes are mostly provided with qualifications that intelligent students trained in the Usul and Furu know. The scholars only remain silent because they trusted the expertise of the students. So in theory, the codes have the highest authority, but in the practice, they cannot be applied without considering the social practice, thus without concretizing them. So don't apply the law without considering the context. So the fact that the law exists in a book does not mean that it must be applied or understood as law. So that means there are rulings which represent a doctrine and therefore have the purpose of studying and represent a doctrine, but at the same time cannot be applied directly since they are not concrete. So let's move to an example to highlight this. Now I want to show a concrete example from Al-Marghinani's Murtaza and his commentary. The example itself is not so important. The structure behind the example is what I'm going to show how legal experts discuss these questions in his works. So the passage I would like to assess deals with usury. In Islamic law, the exchange of gold for gold and silver for silver is considered usurious and sinful unless two conditions are met. Exactly the same weight of metal is exchanged, and the exchange takes place at the same time, on the spot exchange. Then it is not usury. So if the exchange is gold for silver, then unequal amounts may be exchanged, but the exchange must still be on spot. Then there is another discussion on metal purity. What if an item is not pure gold or silver, but mixed with other metals? Hanafis generally applied the rule that an item is treated in accordance with what is predominant in it. Al-akthar lahu hukmul kull. So if it is more than 50% gold, then it is all gold. So the Murtaza says this is the rule. Because the Murtaza says then this is treated like gold. So unequal exchange is not allowed. And then the commentary justifies this rule at length. So we move further. Murtaza then goes to the other question. So what is if the impurity is predominant? Then they are not treated as silver or gold coins. So if predominantly impure items of gold and silver are exchanged with predominantly pure items of gold and silver, then this is valid without any need for equality, because they are treated as different metals. Okay. And then the commentary is justifying this at length, why this should be like this. And then at the end, the commentary said, but this law is not applied. Why? Our teachers did not issue fatwas to permit unequal exchange in adala and ghatarifa, because they are from the most precious forms of wealth in our lands. Where unequal exchange permitted in them, the door of usury would be opened. So there is a law in the Murtaza, which can be classified as non-applied law, according to the Jewish equivalent. The commentary confirms this, but you cannot apply this, at least in that specific region. Why? Because of social considerations. It is clear that according to these teachers, usury is not a mere technicality within trade law, such that as long as one has technically avoided unequal exchange of what is legally considered to be gold or silver, then one has satisfied this aspect of law. Rather, there is a social consequence of this law that must also be considered. So they look at the telos of the law and say that the abstract ruling in the Murtaza undermines this telos, so it cannot be followed in this specific context. The social context leads to a general reflection on the meaning and purpose of the norms. So from very technical legal discussions, we can abstract general discussions on purpose and telos of the norm. Yes, and to see how scholars interpreted the law concretely in the given reality, other genres must be consulted. Fatwas and tractates, treatises are full of examples that deviate from what was laid down as a rule in the Murtaza, as non-applied rule, without questioning the validity of the Murtaza rule. And here we can clearly see the functional interplay between the sacred, ancient law and the applied law. Another example from the same book about paying to teach the Quran. So, in the Murtaza there is the rule, it is impermissible for someone to deliver the call to prayer, to perform Hajj, or to teach the Quran. This last point is our point, or to teach the Quran. This is the rule, the law, non-applied law, the theoretical law. So in the commentary then this is explained and justified at length, in more than just what I here wrote down. So the basis is that, according to us, a Muslim may not be hired for devotional acts he performs for himself to get reward, because it is ibadah. But according to Shafi, it's okay. And then he justifies why this should be the case. And then only to conclude, in a side note, Some of our teachers have deemed it fitting in our time for someone to be hired to teach the Quran because laxness in matters of religion is prevalent. So, in holding back from this, the preservation of the Quran is squandered. This is the fatwa position. So, the same here. He is arguing at length for a position where at the end he says, we are not allowed to answer anyone's questions with. Learn from it, but it is not law. Similar to the Jewish sentence we saw in the first part, so the theoretical law. So the rulings in the Mukhtasar and commentaries are not law, applied law, but proposed law, theoretical law, and represent the ancient tradition of school doctrine. And now let's move again to the Jewish legal literature and look to the functional interplay of different genres within the halakhic discourse. What you can see now. Okay, law and law to be applied. Okay, diversification of legal literature. Let's show this maybe first. So first, a distinction must be made between Ashkenazic and Sephardic Jewry. Writing halakhic codifications and commentaries was exclusively the method of the Sephardic community under the Islamic rule. According to Chaim Simon, Ashkenazis represent a devotional approach to Talmud. That means that Talmud was something to be learned and understood on its own terms. It is foremost a spiritual discourse concerned with establishing a relationship with God, and only secondarily a system of social rules. Therefore, they didn't feel the need to write codes where the concrete applied relevant rules of halakha were collected in systematic way, nor did they engage in philosophical theorizing or were open to the intellectual culture of the non-Jewish world. They continued the study of Talmud in a traditional way by producing commentaries and supplements to Talmudic questions and problems and dealt with legal issues within this web of here. This is, the tradition of the Ashkenazi Jewry. Broad generalization, of course. Like in Islamic legal literature, the Sephardic communities proposed a sharp line between halakha, the legal content, and the agadah, the non-legal narratives, and collected the practically relevant rules of Talmud in independent works and systematized them in new ways. We see the emergence of influential codes of Jewish law, starting with El-Farsi, Maimonides, and continuing with Jacob bin Asher, and finally Yosef Karo's Shulchan Aruch, which is the most influential Jewish book, which was widely used as the most authoritative code of halakha. Since the codices like the Shulchan Aruch provide only black letter rules, usually without argumentation, the need arose to comment on this work again and again, which paved the way for further super-commentaries and super-commentaries. In addition to these codes and commentaries, responsa and takanot, ordinances or enactments, are further layers of legal literature which represent the practical side of the law. But after the 16th century, the distinction between Ashkenazi and Sephardic methods blurred, especially after Shulchan Aruch became the most authoritative book for both communities, and after they started to write extensive commentaries or abridgments of Shulchan Aruch, even in the Ashkenazi tradition. So the Tosafot, the supplements, were integrated into the commentaries, and the commentaries were reflected in the other writings of the Ashkenazi tradition. And also the responsa were integrated into commentary literature. So we have this dynamic functional interplay in the Jewish tradition. So now here's a comparison between, the fiqh and halakha discourse. Most of the time, I read studies where they compare halakha with sharia, and I think this is not an appropriate comparison. From etymologic point of view, this makes sense. Halakha and sharia are very close to each other, but from a conceptual point of view, we have to compare fiqh and halakha and not sharia with halakha. So like in Islamic literature, the legal codes are theoretically more authoritative than the responsa, since they are stating the sacred law. And again, here is the hierarchy between the sources. And in theory, when a halakha from the codices conflicts with a responsum, the view of the codices should be taken into account, because the codes represent the law of the oral Torah. The commentary connects the rule of the codes with the Talmudic background and provides a theoretical scholarly justification for that, similar to the Islamic legal endeavor. So, however, the tension between sacred and applied law stayed also in the later period an important question, also within the codes and commentaries and responsa, which was now negotiated in the different layers of legal literature. So, now an example from Maimonides. The ideal halakha was understood by these scholars primarily as a holy corpus to be studied rather than necessarily applied. And I think this is a very fascinating sentence, which, I mean, I could not find in this clarity in fiqh texts. No, I think this is a good, a way to read also the fiqh tradition, I think, primarily as a holy corpus to be studied rather than necessarily be applied. So even in the codes, we see this tension between applied halakha and halakha as a corpus for study, between the sacred and contextualized law. So, first we have the rule in Talmud, the non-applied law, about the lethal wife. It's a very popular example, the killer wife. If two of her husbands have died, she is not allowed to marry a third one. No, we are looking at the structure and not at the content. But this seems to be an interesting case. So this is the original law in Talmud. Of course, there are discussions on this issue. Another rabbi said, no, she can marry a third one, but not a fourth one. But this is the dominant position. So Maimonides took this position and brings his position in his code, Mishneh Torah, and said, when a woman was married to two husbands and they both died, she should not marry a third. If she did marry, she need not to be divorced. Indeed, even if he merely consecrated her, he may consummate the marriage. So the original rule is still there, but with qualifications. But then, you know what is coming next. In one of his responsa, he said, and the law to be applied, halakha ma'aseh, this is very common, in all the lands of Andalusia has always been that if the husbands of a woman die, one after the other, she is not prevented from remarrying, and especially so if she is young. For one can fear the unfortunate event that she would engage in sexual liaisons, and etc. So Maimonides explicitly acknowledges that there are two different types of law. No, law to be studied, law to be studied and law to be applied, and concrete rulings made on the basis of the latter. So there are three modes of law: law to be studied, law to be applied, and a concrete ruling after a question. So another example from another code from Jacob bin Asher from the 13th century, from the book Arba'at Turim. And it's about commercial interactions with non-Jewish prior to the holy days. Yes. Okay. First there is the rule. It is a Mishnaic rule, which is one-to-one also in his code. It says, 3 days prior to a non-Jewish holiday, Jews must curtail commercial interactions with non-Jewish who engage in foreign worship. The rationale for this is that if business deal is successfully concluded close to a holy day, the non-Jew will offer praise to his God upon visiting the church or shrine for the festival. This is problematic because the Jew will be deemed the proximate cause of an act of foreign worship. He would finance the foreign worship. So after assessing the Talmud's argumentation, why this should be like this, Tur, also Arba'at Turim, the short form is Tur, cites the Tosafot's view, the supplement's view, that the prohibition applies only to commercial interactions involving ritual items used in worship services. So from a practical perspective, this introduces a significant area of exception, since according to Tosafot, most items traded in commerce remain outside the scope of regulation. So the general rule of the Murtaza, of the code, is concretized and narrowed down to only cover small areas, whereas the original prohibition was expressed generally and remains general. But at the end of the sections, you know what will come, he said in his commentary, in these days, however, all these prohibitions mentioned in this chapter are permitted. Moreover, since the majority of our livelihood is dependent on non-Jews and we engage with them in commerce during the rest of the year, if we would separate during the holy days, they would show animosity towards us, and thus it is permitted. So there are several examples where an elaborate discussion of the halakhic rule were presented only to conclude that the rule don't apply. Similar to the example from the fiqh work, where the rule of the Murtaza served as a starting point, but not as law. The bulk of analysis found in this above example is devoted to the non-applied law embedded in the Talmud and the Rishonim's discourse. It is only afterward that Tur, Turim, shifts to how the law functions in these days, namely that the current context renders these laws no longer applicable. But in another commentary on Shulchan Aruch is an abridgment, we can say, of Turim, and there are several commentaries on that. We see a rabbi named Rema saying following, nevertheless, a pious individual should distance himself from joining non-Jewish celebrations, if it can be done in a way that does not result in animosity. So in this comment, the halakha has come full circle. The original rule was a broad prohibition against social and commercial interactions prior to the holy days, but political and economic considerations required them to be narrowed down and eventually read out of practice. In Rema's comment, however, the discussion shifts back towards the original rule, but not as a universally binding legal decree, but rather as an aspirational norm for pious individuals. That is, although the original rule is no longer implemented as law, as an applied law, it still had other functions for believers. Thus, whether our point of reference is the Talmud, the codes, the commentaries, or the responsa, the result is substantially similar or the same. Halakha is not only a flat discourse of legal rules, but concurrently a system of governing rules and practices, a forum for legal analysis, a platform of religious expression, and an object of devotional study. As conclusion, yes, we could see that in both traditions, law does not constitute a flat discourse, but a multidimensional one, which can serve as a forum of ongoing theological, metaphysical, ethical, and social considerations. Sometimes it is explicitly there, sometimes it is implicit. So I think there is much potential to be evolved in that way. So while the Mukhtasars or codes provide the flat black letter rule, the different commentaries provide the theological, metaphysical, or societal implications of the legal rule. For a legal rule becoming an applied law, it has to pass through the filter of reflection on social context. Only then a legal rule from the books can become law. In both traditions, we see the idea of an ideal law, of a theoretical law of the past, the so-called past dependency, the conservative side of the law, and practice law in the present. And we have differentiated between at least three kinds of laws: the law to be studied, applied law, and the concrete ruling. That means not every rule or kind of literature has the same normative weight, and different types of works have different function within the system. By showing the functional interplay between the legal genres, I try to explain how the jurists, on the one hand, ensure the reconnection to the scholastic tradition, but at the same time adapt the law to the changing circumstances. I mean, as I said, seeing the law as primarily as a locus for studying and devotion is a fascinating way to think, to conceptualize also, I think, for the Islamic legal tradition. Of course, we have, concepts like hukum and fatwa, ta'lili and ta'abudi, but I think this is very clear articulated in the Jewish tradition. So, yes, I'm ready. 2 minutes. So other common questions would be, what is the normative role of tradition? How is it understood and interpreted? And the genres seem to play an important role here. Obviously, Jewish authors drew inspiration from Muslim authors in the presentation of their content, and probably this adoption also happened out of similar motives. But perhaps there were other needs that the genres were necessary to meet. Why, for example, is another question. Certain genres were adapted, like Murtaza, commentary, fatwas, and others, and others, like the whole bunch of theoretical genres like usul al-fiqh, not. So it was not simply a matter of adapting, but a conscious use of certain concepts to meet certain needs. And identifying these needs might provide a good impetus for how Jewish and Muslim scholars resolve the tension between stable and flexible elements. On the other hand, legal texts are strongly interwoven with other non-legal genres, such as Talmud and Midrash commentaries in Judaism and Hadith and Quranic commentaries in Islam. This relationship must also be taken into account in order to adequately understand the multi-layered discourse. So, although the two legal systems had many parallels, Jewish law faced very different challenges because of its minority situation than Islamic law, which represented the dominant culture. So how does this difference affect the way in which the scholars conceptualize their own legal systems? And by using the law as a platform for mutual learning and asking the right questions, the law, maybe a comparative theology approach can be fruitful for us. Yes, thank you.